Another brilliant lawyer boldly stand firm on the truth for Nnamdi Kanu and Biafra. He stated that Nnamdi Kanu was arrested, detained and granted bail under strict conditions, but fled Nigeria after his home was invaded by the Nigerian military, resulting in casualties. The Nigerian government did not follow legal extradition procedures when bringing Nnamdi Kanu back from Kenya, violating international law. The Nigerian government bypassed proper extradition protocols despite an existing treaty with the UK and instead abducted Nnamdi Kanu, raising concerns about legality. The court ruled that Nnamdi Kanu's extraordinary rendition was unlawful and dismissed the charges against him, questioning how he was brought back to Nigeria. Despite the court ruling, the Nigerian government is reluctant to release Nnamdi Kanu and is considering other legal actions, raising concerns about judicial integrity. The lawyer explains that while discharge means the charges are no longer valid, the government argues that they can still refile fresh charges. Since all charges have been struck out, Nnamdi Kanu is not legally standing trial, making his continued detention unjustified. The case is seen as a political move rather than a legal one, with the government using Nnamdi Kanu's case to assert power rather than uphold justice. The lawyer demands Nnamdi Kanu's unconditional release and calls for disciplinary action against the Attorney General for undermining the judiciary. I remember the day I first came across the story of Nnamdi Kanu and the turbulent events surrounding him. I was scrolling through the news when I stumbled upon a report that made my heart skip a beat. It was a story not just about legal proceedings or political maneuvering, but about a man whose life had taken a dramatic turn under circumstances that many of us could hardly imagine. The report detailed how a brilliant lawyer had taken a stand and boldly defended the truth about Nnamdi Kanu and the broader issues affecting Biafra. As I read on, I realized that what was unfolding was not only a legal battle, but a significant moment in the struggle for justice and the rule of law in Nigeria. I learned that Nnamdi Kanu, a prominent figure known for his leadership in the Biafra movement, had once been arrested and detained under strict conditions. The government had even granted him bail, though it was clear from the very beginning that his freedom was fragile. The situation escalated dramatically when the Nigerian military invaded the home of Nnamdi Kanu. The invasion was a traumatic event, a day marked by chaos, confusion, and tragically, the loss of lives. It was reported that several people were killed during the military incursion, and even the palace belonging to Nnamdi Kanu's father was desecrated. In the midst of this turmoil, Nnamdi Kanu narrowly escaped, fleeing the country to avoid further harm. I was struck by the intensity of the events and the sheer audacity of what had occurred. Imagine being in a situation where your very home is violated by the state's armed forces, where your life is threatened, and you have to make a split-second decision to leave your country in search of safety. That was the reality for Nnamdi Kanu. Once he managed to escape, he made his way to the United Kingdom, a country where he also held citizenship, seeking refuge and a chance to regroup. Yet the story did not end with his flight. Instead, it took a turn that raised many questions about the way the Nigerian government was handling the case. The government, it seemed, was not following the proper legal channels to bring him back. Instead of submitting a formal extradition request through the correct procedures, as mandated by international law and under a mutual legal assistance treaty between Nigeria and the United Kingdom, the government resorted to what many described as an extraordinary rendition. They abducted Nnamdi Kanu from a foreign land and brought him back to Nigeria without following due process. This blatant disregard for the established legal norms was not only shocking, but also deeply troubling for anyone who cares about the rule of law and human rights. At the heart of the matter was the issue of legality. The brilliant lawyer who spoke up on this matter argued passionately that the process used to bring Nnamdi Kanu back to Nigeria was fundamentally flawed and violated international law. He explained that Nigeria had a legal obligation under both its own Extradition Act and international treaties to formally request the handover of an accused person. This process, known as the extradition process, is designed to protect the rights of individuals and to ensure that any legal proceedings are conducted fairly and transparently. By bypassing this established protocol, the government not only undermined the legal process, but also compromised the very integrity of the judiciary. I found myself reflecting on the significance of this breach. The lawyer's argument was compelling. If the government could simply bypass the extradition process and bring someone back against their will, what did that mean for the rule of law in Nigeria? It was as if the government had decided that the laws did not apply to them, that they could act with impunity. The case of Nnamdi Kanu was quickly becoming more than just a legal dispute. It was emerging as a symbol of the broader struggle against the abuse of power. The court's decision to rule that Nnamdi Kanu's extraordinary rendition was unlawful and to dismiss the charges against him sent a powerful message. It was a declaration that even in the face of political pressure and government overreach, the principles of justice and due process must prevail. Despite this significant ruling by the court, however, the Nigerian government did not immediately release Nnamdi Kanu. Instead, they seemed determined to hold on to him and even contemplated taking further legal actions. This decision, as the lawyer explained, raised serious concerns about the integrity of the judicial system and the motivations behind the government's actions. On one hand, the discharge of the charges meant that legally, Nnamdi Kanu was no longer facing a valid trial. Yet, on the other hand, the government argued that they could simply file fresh charges against him, a move that many saw as an abuse of legal power and a means of continuing to detain him unjustly. I recall feeling a mix of anger and disbelief as I considered the implications of this stance. How could a government hold someone in detention when the court had clearly ruled that there was no case against him? The lawyer's perspective resonated deeply with me. He argued that the government's insistence on keeping Nnamdi Kanu behind bars was not about justice or legal process, but rather about asserting power. It was as if the government was using his case as a political tool, a way to demonstrate its control and to intimidate its critics. In a truly democratic society, such actions would be unacceptable. The rule of law is meant to protect individuals from arbitrary detention and the misuse of state power, not to serve as a weapon in political battles. Throughout the discussion, the lawyer made a clear demand. Nnamdi Kanu must be released immediately and unconditionally. He went further, calling on the Nigerian Bar Association to take disciplinary action against the Attorney General, whose actions had, in his view, undermined the sanctity of the judiciary. The lawyer's words were not merely legal arguments. They were a passionate plea for accountability and a reminder that the government's actions must always be subject to legal scrutiny. As I continued to reflect on the story, I began to understand the broader context. The lawyer had been following the case for some time, since the very moment when Nnamdi Kanu was first arrested and detained by the State Security Service. I imagined him poring over documents in his office, reviewing every detail of the case and forming a narrative that was both legally sound and morally compelling. He recalled the day when charges were formally brought against Nnamdi Kanu in a federal court in Abuja, presided over by a respected judge. The charges, however, were not the end of the story. Soon after, as events took a dramatic turn, Nnamdi Kanu was forced to flee the country, leaving behind a trail of legal complexities and unresolved issues. One particularly poignant part of the narrative was when the lawyer recounted the invasion of Nnamdi Kanu's home by the Nigerian military. He described the scene with a vividness that brought the events to life. The military's actions were not only a violation of the sanctity of a person's home, but also an attack on the very notion of safety and security that every citizen should enjoy. The chaos that ensued, a chaotic blend of fear, violence, and loss, was something that could not be ignored. It was this tragic episode that in many ways set the stage for everything that followed. Had it not been for that fateful day, when the military invaded his home and the tragic events unfolded, Nnamdi Kanu might never have felt compelled to leave Nigeria. The lawyer made it clear that this incident was a turning point, one that forced a man into exile and raised serious questions about the state's use of force. I found myself thinking about the broader implications of this incident. It was not just about one man or one case. It was about a pattern of behavior that threatened to erode the foundations of justice in the country. The extraordinary rendition of Nnamdi Kanu, carried out without the proper legal processes, was emblematic of a larger problem. It demonstrated that when a government decides to act outside the boundaries of the law, it sets a dangerous precedent. How could citizens trust a system where legal procedures were ignored for the sake of political expediency? The lawyer's argument was clear. If we allow such actions to go unchecked, we risk undermining the very essence of what it means to live in a society governed by law and order. There was also a detailed discussion about the legal technicalities that surrounded the case. Terms like discharge and acquittal were thrown around. The lawyer took the time to explain the difference between the two. In his simple conversational way, he made it clear that an acquittal means a complete exoneration, where the court finds that there is no case against the accused. A discharge, on the other hand, might arise from technical defects in the charges, meaning that while the charges are dismissed at that moment, there is a possibility that the prosecution could refile new charges at a later date. In the case of Nnamdi Kanu, the court had essentially struck out all the charges. This meant that, legally speaking, there was no case for him to answer, and yet here he was, still held in detention. This explanation struck a chord with me. It seemed absurd that a man could be held indefinitely when there was no valid legal basis for his detention. The lawyer's frustration was palpable as he questioned how the government could justify keeping Nnamdi Kanu in custody when the legal process had already determined that there was nothing to answer for. He argued that this was not just a legal issue, it was a matter of fundamental fairness. In any just society, if a person is not being prosecuted for a crime, there should be no reason to keep that person confined. The continued detention of Nnamdi Kanu, therefore, was not only a violation of legal principles, but also a profound injustice. What was perhaps most striking about the entire episode was the political undercurrent that ran through every aspect of the case. It was becoming increasingly clear that this was not merely a question of legal procedure or international law. Instead, it was about the use of the law as a tool for political ends. The government's actions, from the military invasion of a private home to the bypassing of established extradition protocols, all pointed to a broader strategy. It appeared that the authorities were less interested in pursuing justice and more intent on demonstrating their power. In this context, the legal case against Nnamdi Kanu was seen by many as a political move, a way for the government to assert control over a figure who had become a symbol of resistance and hope for many in the Biafra movement. I remember feeling a sense of disillusionment as I thought about how power can sometimes distort the application of justice. The lawyer's passionate defense of Nnamdi Kanu was not merely an isolated incident. It was a reflection of a deep-seated belief that justice should not be sacrificed on the altar of political expediency. He argued that if the government were allowed to act with impunity, if it could simply disregard international law and the principles of due process, it would set a dangerous example for the future. The case of Nnamdi Kanu, in his view, was not just about one man's fate. It was about the very future of Nigeria's legal and political system. As the discussion unfolded, the lawyer also touched on comparisons with other cases that had set precedents in the past. He recalled instances when similar actions had been taken in different contexts, a reminder that the misuse of legal procedures was not a new phenomenon. One particular comparison he made was with a case involving another prominent figure who had been abducted under controversial circumstances. In that case, as in the case of Nnamdi Kanu, the government had taken actions that were widely seen as extrajudicial and politically motivated. These comparisons served to underscore the fact that when a government starts to bypass established legal protocols, it not only endangers individual rights, but also threatens the stability and integrity of the entire judicial system. The conversation eventually turned to the question of what should happen next. The lawyer was unequivocal in his demand. Nnamdi Kanu must be released immediately and without any conditions. He maintained that holding him in detention was not only legally indefensible, but also morally wrong. In his view, the only just course of action was to set him free and allow the legal process to proceed in a manner that respected both national and international law. Moreover, he called on the Nigerian Bar Association to take a stand and to hold the Attorney General accountable for what he described as an egregious disregard for the Constitution and the principles of justice. It was a plea not only for Nnamdi Kanu, but for the integrity of the entire judicial system, a call to ensure that no government could ever again justify similar actions. I found myself reflecting on how the situation had escalated to such a critical juncture. The legal arguments, the political implications, and the human cost of the events were all intertwined in a complex web that defied easy explanation. Here was a case that had started with a series of legal technicalities and ended up touching on issues of state power, human rights, and the very nature of democracy. It was a story that had evolved in real time, with every new development adding another layer of complexity to an already intricate narrative. Throughout all of this, the lawyer's voice remained steady and resolute. His words, delivered in a calm yet impassioned tone, painted a picture of a man who was not willing to compromise on the principles of justice. He spoke not as an outsider, but as someone who had followed the case from its inception, someone who understood the stakes and was determined to see that the truth prevailed. In his own words, he explained that the process by which Nnamdi Kanu had been brought back to Nigeria was not just a technical error, it was a fundamental breach of the law.
Of this Nnamdi Kanu development, can you share with us? What do you know?
Thank you once again for inviting me. I have followed the Nnamdi Kanu's case right from when he was arrested, detained by the State Security Service, to when the federal government eventually filed charges against him at the Federal High Court in Abuja before the Honorable Justice Binta Nyako, to the point where he was admitted to bail on various stringent conditions, and subsequently the military invaded his home, and then a couple of people were killed, the palace of his father was desecrated, and he narrowly escaped and fled the country. You know, one conversation that we must have is this: when matters of this nature arise, it is always important for us to get to the root of it. The reason why we are having this discussion today, the reason why the Court of Appeal judgment came, is because the Nigerian army invaded the home of Nnamdi Kanu. Had that very tragic incident not took place, Nnamdi Kanu probably would not have left Nigeria. Because when we say he jumped bail, I have some difficulty agreeing with that, when someone basically escaped for his life. But that is an argument for another day. Now, granted that he left Nigeria and found his way to the United Kingdom, where he's also a citizen, and then the federal government went back to court, Nnamdi Kanu was nowhere to be found. There was even an attempt to go after his trustees, and at some point the court even threatened to have his sureties forfeit the bond that they have entered. while signing as sureties for him to be released. Now, eventually the court had to issue a warrant for his arrest, and then the federal government did not approach the government of United Kingdom with an extradition request, because I can confirm to you that there is what is called a mutual legal assistance treaty between Nigeria and the government of United Kingdom. And indeed, under our Extradition Act, Nigeria had a legal obligation under its own law and, of course, under international law to ensure that where a fugitive, where someone is wanted in respect of an offense that is committed in Nigeria, Nigeria must formally request the country where that person resides to bring that person, that is to put it in a layman's language, to produce that person or allow the Nigerian authorities to take custody of that person. That process is what is called the extradition process. And we have seen that with the case of Nnamdi in Niger Republic, if I'm not mistaken. Now, we have also seen that in the case of Abayari, where the United States government made a request to the Nigerian government. And then the same Malami, who is now issuing statements, went to the Federal High Court and basically, sabotaged the entire process by allowing the NDLEA, the Nigerian Drug Law Enforcement Agency, National Drug Law Enforcement Agency, to file charges against Abayari, even when the extradition proceedings was ongoing, contrary to the provisions of the Extradition Act. The point I am making is that under international law, and indeed under our law, there is a clear procedure by which a fugitive is to be produced to stand trial. Now, what has been the response of the Nigerian government when this issue of extraordinary rendition was raised? Silence at the Federal High Court, and that is the point the Court of Appeal has made yesterday. The Nigerian government had absolutely no answer to one important question. How did you secure the attendance of Nnamdi Kanu in court? Because except we are a banana republic, except we are a country that is not governed by laws, you cannot go to a foreign land and then abduct somebody and forcefully bring that person into Nigeria and say you want to put that person to trial. So if we allow that kind of precedent to stand, if the Court of Appeal were to say there is nothing wrong with extraordinary rendition, that will be a fatal attack on the Constitution of Nigeria. It will be an attack on international law. And let me also highlight this. Under Section 2 of our Constitution, the Constitution says that the Constitution shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria. Yeah. In other words, if you look at by the combined effect of Section 1 and Section 2 of the Constitution, the Nigerian Constitution does not have extraterritorial application. In other words, you cannot go to the United Kingdom, you cannot go to Kenya to enforce the provisions of the Nigerian Constitution. Yeah. Let alone an act of parliament.
Yeah, Iniebehe, just a minute. Two key words here: discharged and acquitted. When are you discharged and when are you acquitted?
Well, these are, terminologies that have implications in law. But let me also caution that there are circumstances under the law under which a discharge can be taken as an acquittal. And I think Nnamdi Kanu's case is within that contemplation. We will wait to see whether there will be a different outcome, really, because I have read the statement of Malami that, he was only discharged. He was not acquitted. So having been discharged, right, why are you still keeping on to him? Can you hold on to someone who has been discharged in law? Acquittal is typically when a case is determined on the merits and the court finds that the prosecution has not proved its case. And that is some form of absolute exoneration. Whereas a discharge can arise from several circumstances. For example, where the charge against a defendant is defective. That person can be discharged, which ordinarily would entitle the prosecution to refile the charge under some certain circumstances. Now, in the case of Nnamdi Kanu, right, the issue is very simple. And it is this: when you look at the charge that was brought against him, even the Honorable Justice Njako of the Federal High Court agreed that at least eight of the counts in the charge were incompetent and struck them out. There was a further appeal to the Court of Appeal. From what I have read, because the CTC of the judgment of the Court of Appeal is not out yet, but from what I have read, including the comment made by Chief Mike Ezekume, it appears the Court of Appeal has even struck out the remaining counts. And if that is the implication, it means that today Nnamdi Kanu is not standing trial before any court. So let nobody say that there is a subsisting case for which Nnamdi Kanu is to answer to.
Okay.
And that brings me to the provisions of Section 287 of the Constitution.
That matter.
Section 2, which says
that matter for which he was standing trial before he left Nigeria, citing threat to his life.
Yeah.
Is that particular matter statute bad at this time? Can they go back, because the Attorney General was referring to that there were some things that happened before he fled Nigeria? Can they go back and file fresh charges based on what
That happened
they
before.
were? Yes, what had happened before, what they were trying him for at that time?
it is very doubtful, really, because the question is, before how many courts in Nigeria is Nnamdi Kanu standing trial? Is Nnamdi Kanu standing trial for more than one charge? To the best of my knowledge, from the findings I have made, it appears he only stood trial before Justice Iniebehe for one charge that had several counts. That charge no longer exists in law. So this argument that he was only discharged and that the issue that took place before the extraordinary rendition is not affected, for me, is baseless in law. What the Court of Appeal has done is to say that the very basis upon which you brought him back to continue to face trial is defective. But let us even assume for a second, right, that Malami is right, that they have the power to refile charges. You cannot hold a citizen in anticipation of a charge that you intend to file. Because for them to say that they will explore legal options, what legal options are you going to explore? I find it quite condescending. It is an insult on the judiciary for the Court of Appeal to give a decision. And then the National Security Council had to meet, as I read today, and then the AGM had to even issue a statement to say, we are considering what we are going to do. In other words, we want to review whether to comply with the order of the court or not. For me, that even takes me to the point I've always made, that in these political cases, the intention is not really to punish for a crime. It is just an attempt by the government to show power. Because if you are saying that Nnamdi Kanu has committed an offense, you cannot try him outside the law. You cannot try him outside the due process of law. And this comment is coming from no other person, the Attorney General of the Federation. Now, when you look at Section 150 of the Constitution, it says that the AGF shall be the chief law officer of the government of the Federation. So when you have a chief law officer desecrating the sanctity of our judiciary, basically giving excuses why they will not comply with the subsisting and valid order of the court, that begs the question, are we really running a democracy? Because we have read the story of Diko, who was also abducted abroad and brought to Nigeria under a military dictatorship, under the same General Buhari, if I'm not mistaken. And now history is repeating itself. But the Court of Appeal is basically punishing the Buhari regime by saying that because you did it to Diko under a military dictatorship and you got away with it, you cannot repeat it under a democracy. That's what the Court of Appeal.
They actually tried to bring Diko here but failed.
Yeah.
So they didn't succeed. That abduction didn't succeed.
Yes, they didn't
Yeah.
Yes, I'm saying
the secretary was able
you
to
tried
see
it. I'm saying that you tried it under the military, right? And you got away with it, even though it was not successful.
Yeah, it was
now,
not successful.
you even succeeded under a so-called democracy. Are we saying that there should be no consequence? That the Nigerian state can go to a foreign land and just abduct it? Look at Niger Republic that we want to look down on. Look at what they did with Sunday Igboho. They insisted that the process of law, the due process of law must go through. Why are we reluctant to insist on the rule of law? And for me, and this is the point I want to make.
Iniebehe, I'm sure you meant Benin Republic.
Benin, yes.
Okay, Benin.
Yes, Benin Republic.
Yeah, quickly, in 30 seconds. What next, in your estimation?
Kanu has to be released immediately and unconditionally. The alternative to that would be for the Nigerian Bar Association to immediately commence disciplinary action against the Attorney General of the Federation. Because we cannot tolerate this. When the court has given an order, look at the ASU strike.
Iniebehe, we thank you very kindly.
That the court has given an order for ASU to resume. So you cannot be picking and be choosing which order of court to obey.
Iniebehe, you are not 1/10 as enraged as we are here, but time is a master. But let's thank you very kindly for your intervention. Thank you.
This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.